Good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati. Yes, signing in for Companies Law, Companies Act 2013. Today, we are going to see the new topic, registration and incorporation of a company. So normally what happens is there are three stages in the formation of a company. First one is promotion of a company. Second, registration and incorporation of a company. Third one is commencement of business. So first stage is promotion of a company. Here promoters will be there. So they originate the idea of forming a company and they take necessary steps in this regard. The persons who think of forming a company, they make necessary steps in its formation and they are known as promoters or company promoters. First, what happens? Promoter think of establishing a company. They take all the necessary steps in formation of the company and they are known as promoters or company promoters. Now, once they have taken all the necessary steps for promoting a company, then they will go for registration and incorporation of the company. In fact, it is the second stage in the formation of a company. So, time and again, we know that a company comes into existence when it is registered under the Companies Act. If the company is to be formed as a public company, any 7 or more persons associated for any lawful purpose may form the same by getting it registered with the Registrar of Companies. In case of a public company, minimum 7 or more persons. And if the company is to be formed as a private company, any 2 or more persons, remember, not exceeding 200, may get the same registered. So, now what happens? You have to decide whether you are going to incorporate a public company or whether you are going to incorporate a private company. First you have to analyze. Now, after getting your name approved from the Registrar of Companies, you have to approach the Registrar of Companies with the following documents. So first one is, the two basic documents. One is Memorandum of Association, another one is Articles of Association. So first you have to prepare the Memorandum of Association. It is the document which describes the scope of company's activities. So 6 clauses will be there: name class, registered office class, object class, liability class, capital class, association or subscription class. First you have to prepare the Memorandum of Association and it must be signed by the required number of persons which are necessary for the formation of the company. So first what you have to do, you have to prepare Memorandum of Association. Then apart from Memorandum of Association, you have to prepare Articles of Association. Articles of Association, it is the document which contains the rules and regulations of the company. It must also be signed by the persons who sign the Memorandum of Association. Whoever is signing Memorandum of Association, the same persons has to be sign the Articles of Association. Remember, Articles of Association is compulsory for three types of companies, namely unlimited companies, private companies, and companies limited by guarantee. However, filing of this document is not compulsory for a public company limited by shares. If a public company limited by shares does not file this document, it is deemed to have adopted Table F of Companies Act. So, public company need not have its own articles of association. It may adopt Table F. Table F is given in the Schedule to the Companies Act 2013. So, first you have to prepare Memorandum of Association. Second, you have to prepare Articles of Association. Next, third one is the agreement which the company proposes to enter into with an individual as appointment of company's managing director, whole-time director, or manager. If you enter into any agreement with any person who wishes to be appointed as a managing director or whole-time director or manager, you have to file that agreement also. Next one is the declaration that all the requirements of the Companies Act have been complied with. You have to file a declaration with respect to what? That the company has complied with all the elements that have been specified under the Companies Act, all the procedures prescribed under the Companies Act. Now, you have to give a declaration. This declaration must be signed by any one of the following persons. So, this declaration should be signed by an advocate of the Supreme Court or High Court, an attorney or pleader entitled to appear before High Court, a company secretary in whole-time practice in India who is engaged in the formation of a company, a chartered accountant in whole-time practice in India who is engaged in the formation of the company, and a person named in the Articles of Association as a director, manager, or secretary of the company. So you have to prepare one declaration declaring that all the requirements of the Companies Act have been complied with, and they have to be signed with respect of these different persons. Right now, a written consent of directors to act as a director of the company. If anybody accepts to be appointed as a director of the company, you have to take written permission from that director. It should be signed by the director himself or by his agent, authorized in writing. A written consent of the directors to act as a director of the company. Written consent means yes, he is signing the agreement. Next one is a written undertaking by such a director to take qualification shares. Qualification shares means if you want to become a director in a company, you have to take minimum one share each. So a director, if he wants to be appointed as a director, he has to do two things. He should possess DIN, DIN, director identification number. He has to possess director identification number. He has to apply in the Ministry of Corporate Affairs portal. Second one is he has to take qualification shares. Qualification shares means if you take that shares, you will be qualified to be a director in the company. Unless and until you take that qualification shares, you cannot become a director on the company. So this is with respect to qualification shares, and a list of persons who have agreed to become the first director of the company. So you have to prepare a list of written consent and who have agreed to become the first directors of the company. So normally directors will be appointed in the annual general meeting, but till that appointment has been validly made, who are the persons accepting to be the first directors of the company. So now the application for registration of the company along with requisite fee and documents is presented to the registrar for registration. The registrar shall satisfy himself with respect to the following things. First one is The company is proposed to be formed for lawful object. Company should be for lawful object. The memorandum of association has been signed by the requisite number of persons, 7 in case of public and 2 in case of private company. The memorandum of association and articles of association are prepared according to the provisions of the Companies Act. They do not go against the Companies Act. Now, the statutory declaration has been duly signed by the authorized person. Declaration we have dealt with it, and name of the company is acceptable, that is, the name is neither prohibited nor is similar to the name of any existing company. On being satisfied with all the above points, then what happens? The registrar will register your company and place the company in a register known as Register of Companies. After the registration, the registrar issues a certificate of incorporation. Once a certificate of incorporation has been issued by the registrar, the company comes into existence. Now you have understood the procedure. You have to file all the above documents, and once everything is in order, the registrar will issue certificate of incorporation. Let us discuss about the certificate of incorporation. A certificate of incorporation, it is the one which certifies that the company is incorporated. Who will issue this? By the registrar of companies. It is issued by the registrar of companies. It contains the name of the company, the date of its issue, and the signature of the registrar with his seal. This certificate brings the company into existence. Now, once you go to the registrar, file the above mentioned documents, the company comes into existence. Once the company comes into existence, the registrar will issue a certificate of incorporation, and that certificate of incorporation is the conclusive proof that your company is being registered. In fact, the legal effects of the certificate of incorporation is the company comes into existence and becomes a legal entity independent from its members. So time and again we are discussing about separate legal entity. Right? Now the company's life starts from the date of certificate of incorporation. One certificate of incorporation has been issued, the company's life starts from this date of certificate of incorporation, and the company acquires perpetual succession. It remains in existence forever unless it is wound up according to the provision of the Companies Act. In other words, death, retirement, admission, etc. of the members of the company does not affect its existence. Next one is the memorandum and articles of association becomes binding upon the company and all its members, and the liability of the members of the limited company becomes limited. So the certificate of incorporation, it is the conclusive proof of registration of the company. In other words, it is considered as the decisive and final as regards the registration of the company. Remember, you cannot dispute the validity of the certificate on any ground whatsoever. So, certificate of incorporation is conclusive on 3 points, that all the precondition, that is legal requirements of registration, have been complied with. Next one is that the company is properly registered. Next one is that the company came into existence on the date of certificate of incorporation, right? Once the certificate of incorporation has been granted to you, the company comes into existence, it becomes a legal entity independent from its members. The company's life starts from this date of certificate of incorporation. The company acquires perpetual succession. Memorandum and articles of association becomes binding upon the company and all its members, and liability of the members of the limited company becomes limited. Here, for the conclusive proof of the certificate of incorporation, one case law has been given in your examination. The case law name is Jubilee Cotton Mills versus Lewis. Let us see what happens in this case. The documents which are required for the registration of the company were delivered to Registrar of Companies on 6th January. Remember, on 6th January, the company has delivered the Articles of Association, Memorandum of Association. When? 6th January. After 2 days, that is on 8th January, the registrar issued a certificate of incorporation. When the registrar has issued on 8th January, but it was dated 6th January instead of 8th January. You understand? Memorandum of Association, Articles of Association has been given to the registrar on when? 6th January. After 2 days, the registrar has issued certificate of incorporation but putting the date as 6th January. In fact, it was issued on 8th January. Now what happens? On 6th January, that is before certificate of incorporation was actually issued, the company made allotment of shares. Now the question arose about the validity of the allotment as it was made before the issue of certificate of incorporation. In fact, when the certificate of incorporation was issued 8th January, date is 6th January. That means it is deemed to be issued on 6th January itself. It was held that allotment of shares was valid as in law because the company was formed on 6th January and but not on 8th January, even though originally certificate of incorporation was issued on 8th January, dated 6th January. The reason for the same is certificate of incorporation is conclusive evidence of all that it contains, which that means that all the precondition legal requirements of registration have been complied with, that the company is properly registered, that the company came into existence on the date of certificate of incorporation. A certificate of incorporation, it is therefore conclusive evidence that everything is in order as regards registration and that company has come into existence from the earliest moment from the date of incorporation stated therein with rights and liabilities of a natural person competent to enter into a contract. Now the company is to be registered with legal objects only. If the company registered with illegal objects, then objects do not become legal by the issue of certificate of incorporation. That means the certificate of incorporation is not conclusive of the legality of the objects stated in the memorandum of association. Yes, students, got something today? This is Sreekanth signing off today. Have a good day.